Joining the meeting.
Hi, Josh. Can you hear me? Perfect. I'm just going to have you put yourself on mute for now, okay? Once you hear me call the case, you can remove the mute. This is the clerk. Yep. So just go ahead and put yourself on mute and we'll get started shortly. Thank you. It should be down toward the bottom, like it'll look like a little microphone. Oh, perfect.
Yes, she's down there now.
You guys have been doing that forever.
I know, I go to court. All I've got to do is pay my
I'm
court
gonna
costs.
stand where she stand.
She only had like 2 classes left.
There may be
But
a
I
little
might
echo.
transfer to another.
You have
class
to
in
mute yourself
6
in
months.
this application.
Elizabeth, can you hear
Mute
me?
yourself over here. I did.
Okay.
Yes, I can. Yes, I can.
I'll call you later.
Okay, if I can have you put yourself on mute.
Excuse me. Excuse me.
You know, if I can have you log off and log back on, there's just a really bad echo.
Okay.
Oh, perfect. Mara, can you hear me? Mara Chavez, can you hear me?
Yes.
Okay, so if you just want to put yourself on mute for now.
Yeah, huge echo.
And then Dominic, can you hear me? Dominic, can you hear me?
Can you hear me?
We're gonna have to chop this up anyway.
Elizabeth, can you hear me?
Huh?
Yes, I can.
Can't put this
Perfect.
shit
If you
on
just
lock.
want to go and put yourself on mute, okay?
And where's
It should be down at the bottom. It looks like a little microphone. Rodolfo, can you hear me?
handle all this shit at once. Right?
You object. If they didn't have, they weren't ready for trial, then you shouldn't.
Yeah, I know. You announced ready. I'm ready. Let's do it. Huh?
Antonio, can you hear me?
Yes.
Okay, give me 1 second. Antonio, have you submitted your proof of your alcohol or substance abuse treatment?
So I'm still trying to get to a place to access Medicaid.
Okay. You just want to go ahead and put yourself on mute for now, okay?
Okay.
Thank you.
That's fucked with the wrong chicken. Wow. $21.
Good afternoon, everyone. Thank you for joining virtual courtroom today. I'm Judge Flanagan, and I'll be hearing your cases. Thank you all for muting your devices until we are ready to call your case. Thank you so much.
Cheers. And break.
Cynthia, are you there?
I am, yes.
Oh, okay. I just the camera is where I would normally be sitting. So I'm
Oh, yeah. Sorry, I think they had vet court this morning and
they must
it's
have.
not showing up here, so.
Okay. Ready for the first case?
City of Lakewood versus Joshua Lyons, case number L677007.
Susan Allen for the city, Your Honor.
Mr. Lyons, are you there?
Yes.
Hi, Mr. Lyons. This is Judge Flanagan. Can you hear me okay, sir?
I can.
Okay, thank you so much for appearing today by phone. I know you are currently set for a trial that is scheduled for tomorrow. The city attorney has filed a motion to continue. Ms. Malcolm, any additional record you wish to make regarding that motion?
Objection, Your Honor.
No, and I assume you are objecting, sir, but I just needed to hear if the city attorney wanted to make any additional record about your. Okay, go ahead, Ms. Malcolm.
Briefly, I just wanted to let Mr. Lyons know and the court know that I just found out about the conflict with the agent after we did the status conference last week. So I do apologize, but I did file this as soon as I could, and I wanted to get this heard on the record so that you could make a ruling prior to the trial date tomorrow. Thank you.
Thank you so much, Ms. Malcolm. Mr. Lyons, any record you wish to make about the city's motion to continue?
No, I'm making a motion to dismiss as well. As a matter of fact, I'd prefer it to be a motion to discharge. If we're making motions today, then let's make motions.
All right. Are you referencing the supporting document you filed yesterday, sir?
Sure. I mean, that's a conditional. I mean, that's my plea. That's what I wanted to happen in the first place. And if you can't fix the defects of the case, then I don't think we should go any further anyway.
I understand your position, sir, and your motion to dismiss or for discharge is denied. Do you have any record you want to make regarding the motion to continue that the city attorney has filed?
I'm not making any motions that they were prepared for court 2 days, 3 days ago, whatever. Now they should be prepared. They announced ready, so I'm ready. So let's do this.
Understood, sir. Give me just a moment, everyone, to get to the right screen.
Careful, bias.
This matter comes before the court on the city's motion to continue. Ms. Malcolm made the record that although she announced ready at the status conference last week, she found out after the status conference that the necessary witness, one of the Lakewood agents, is unavailable and would not be able to be here. In this case today, the court shows that this is the first trial setting in the case. There have not been any other continuances. I note that a not guilty plea was entered on August 26th. So we have quite a bit of time before speedy trial runs. In this matter, the court notes the defendant's objection to any continuance as he is ready to proceed to trial. Mr. Lyons, if the situation were reversed and if you were the one asking for a continuance today and the city attorney was objecting because one of your witnesses was unavailable, I would be doing the exact same thing. I would grant the continuance because this is a first trial setting. The city has a right to be able to try and prove their case. And I find that there is ample time in speedy trial. This case was set rather quickly, all things considered. I understand you're ready to go to trial. I can appreciate this is frustrating, but the court is going to go ahead and grant the city's
I object. I absolutely 100% object. That you have to. They have to prove their case. They said they were ready. This is ridiculous. I asked you for a continuance the last time we talked at the status conference, and you told me that I was going to be held to the same standards as a lawyer, and you set it for trial. So if you don't want to be fair and equal, then go ahead and grant this today. But I object.
So, sir, cut out on me. Is there any other record you wish to make?
Well,
I heard the part where you said that I wasn't being fair and equal. Was there anything after that?
Yeah, there was. I asked for a continuance at the status conference so I could catch up on your rules and procedures. And you told me that I was held to the same standard as a lawyer. So they are held to the same standard. They are not. They announced ready. So they're ready. Period. That was the last it's too late for motions anyway, according to your rules. Civil Rules of Municipal Procedure, Rule 212, states that time for making motions. The motion shall be made before the plea is entered, but the court may permit it to be made within a reasonable time thereafter. 2 days before trial is not reasonable time thereafter.
Anything further, sir?
The decision's already been made as well, Your Honor. You already made this decision, so we're set for trial.
Okay, thank you so much, Mr. Lyons, for that record.
Okay,
Noting the defendant's objection, the court is granting the motion to continue. So, sir, I know you've had your opportunity to speak. Now it's the court's turn. You referenced the fact that you asked for a continuance, so the fact that you are now saying that
you
the
told me
court is
I
being
had to be
unreasonable
held
by
to a
granting a continuance. Sir, I'm not going to argue with you. The court's granting the city's motion to continue.
Excellent. You just said you're a liability. I don't care.
What's going to happen next is our Violations Bureau is going to be calling you and will give you the new trial date.
Violations Bureau?
No. It's our clerk's office, sir. It's our clerk's office. And then when come back for that next trial setting, if the city attorney, again, doesn't have their necessary witnesses, if you request a motion to dismiss because they're asking for another continuance, the court most likely will have a different response for you because they will need to be ready to proceed.
Well, they should have been ready to proceed now. This is a farce. You're a biased judge. That's biased.
The court is?
Yeah, you're biased.
Sir?
You're 100% biased. And it says in the judge's canon right here that I can point to your bias to this litigant that you have to recuse yourself.
Let's go ahead and recuse.
Yeah, so you can go ahead and recuse yourself right now.
You
have high.
myself, however.
I recuse you. I have no confidence in this court's rulings.
All right, so what's going to happen next is our clerk's office will be calling you with that new court date, sir.
Okay,
and
you'll be getting
you should be rest assured that I will not be the judge handling, I'm not recusing myself, but I'm not handling trials right now because those are in person. So you'll have a different
judge. Be a new judge?
Which should make you feel
so that's
better.
3 judges
Pardon?
on one matter? 3 judges on one matter? Are you serious? How do you guys ever get the story straight?
So, sir,
how do you keep records?
I'm really confused what you're saying now,
yeah,
sir.
I'm really confused too because I started off with Stavage, now I have you, and now you're telling me you're going to go to another one? Like, well, how do you guys ever keep records?
So, sir, it may be Judge Stavage again. I don't know. There are 3 courtrooms in the city of Lakewood, A, B, and C, depending on the docket that day will depend on where you go for your trial. So I don't know which judge you will see for your trial, sir. And that's not unique to you. That's everyone who goes to the Lakewood Municipal Court right now.
Oh, that's super excellent. That's a real good way to never give anyone a fair trial. If you just keep
so, sir, I'm sorry you're disappointed. Any other record you wish to make?
Your court is a joke.
I hear you feel that way, sir. So our clerk's office will call you shortly with the new trial to court date. Thank you for appearing.
Okay, I expect a response on that plea motion or the plea is
already set as trespass.
For everyone who's just joined the virtual courtroom, if you please put your device on mute so we don't get feedback, and that's Mr. Rotella. If you could try to do that, please. So in looking, sir, at your supporting document, the court finds in looking at that that is virtually identical to previous motions you had filed, which the court is not going to take up today, because you are correct. Substantive motions may not be filed past this time. The city attorney filed a motion to continue as soon as they learned that their witness was unavailable.
Yeah,
So-
there's bias again. I love you. You're
All
my
right,
favorite
sir.
judge.
Thank you for appearing, sir.
Yeah, thank you
We'll
for
go
being
ahead
biased.
and move you from the virtual courtroom, and our clerk's office will call you with your new court date.
Is that
Thank
an
you.
order? Is that an order, Your Honor? Are you ordering me to court again?
So, sir, tomorrow's court date is vacated. You will have a different trial to court date,
Okay,
and
but
you
that
will
doesn't
need
answer
to
my
appear
question.
on
Is that
that
an
date
order?
and time.
Is that an order for a new trial? A new trial date? Is it
Yes.
an order?
Yes,
Thank you.
it is.
Have a good day.
Bye-bye, sir.
More money. Money, 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 money.
Almost had her. The problem is, when she sits there and makes a leading remark like that, and you don't say anything, then that is the standing remark, the last thing said in the record, meaning that that was standing. Okay, your plea is still not guilty. There should be trespass. And you didn't get her to recognize that. I did not plead that.
Whatever, man.
You do not have authority to
Did you
plead
not
for
fucking hear a word?
Okay,
she
yes,
was
I
saying?
did. I'm trying to tell you the place that you could have changed something around there. The plea at least could have been changed. She's going to sit there and
You are correct.
be all blatant
I-
in her decision that she's going to grant a continuance in favor of the prosecution in accordance to her right. The prosecutor has no rights. No, don't touch.